And senior legal instructor for Blue to Gold Law Enforcement Training with my co-pilot.
Hi, I'm Brooke Rohrbaugh. I'm the National Account Director, so I'm the one who's in charge of setting up all of the in-person, on-demand, and online trainings. If there's anything I can ever do to help, give me a call direct, 702-847-7499.
And I know what you're thinking out there. Anthony, can Brooke start doing these roadside chats? And the answer is no. Okay, she's busy. Okay, so this is a question from an officer in Minnesota. And it says, Anthony, what is the case law on restricting movement for officer safety? Let me give you some background here. Say I'm outside of the home, or actually inside the home for a domestic disturbance, talking with one of the involved individuals. That individual is pacing back and forth, maybe trying to go through personal property, messing with their purse, backpack, etc. You tell this person to stand still for officer safety, stop moving around. But he ignores you and continues to go into closets, drawers, etc. Would this be obstruction? Okay, let's stop right there. The biggest, the answer is yes, potentially this is gonna be obstruction, right? Obstruction is basically when people are preventing you from doing your job. You have the lawful authority to control people's movements during an investigative detention. The key case on this, let's just go back to Terry. Terry versus Ohio states in there that the purpose of an investigative detention is to maintain the status quo. Status quo is basically keep everything the same while we try to figure out what is going on, and then we go from there, whether we release them, arrest them, etc. So when you are telling people, hey, don't go messing with your property, stay here, sit on this curb, sit on the couch, and so forth, that is maintaining status quo. There is not going to be a case out there that says that officers cannot order people, within reason, to stay here, don't put your hands in your pockets, don't go through your bag. There's no case out there that's going to say you can't do that because you are allowed to maintain reasonable safety measures during that investigative detention. The officer also says, say I'm also searching a vehicle on a traffic stop and want the occupants to sit on the curb for officer safety, but they ignore that order. Again, would this potentially be obstruction? The answer is yes, but let's use good judgment. Let's also try to de-escalate the situation. The old ways of ask, tell, make are a little, not super workable in 2022 and beyond. Ask them, try to get their cooperation, explain them the repercussions of non-compliance. Hey, look, I don't want to make this more difficult. I have a right to search your car under probable cause, whatever. I don't want to hit you with any other charges. Let's just see what you have. Let's go from there. But, try to get their voluntary compliance, right? The last thing that you want to do is go hands-on with everybody that doesn't sit on a curb within 2 seconds because they're just kind of pushing back and giving you a little contempt of cop behavior. It's your case. It's your use of force. Try to prevent it and reduce use of force when we can. Right, Brooke?
Right.
Let's make good case law. But there's the law. The Constitution's in your favor and so forth. So before we leave, again, you have Brooke's information. She's also on the website, bluetogold.com. If you want to bring me, my other instructor, Ann Kelleher, or other instructors to your agency and train your whole agency in what we do and make good case law, and chiefs out there, we can save a lot of money.
Yes, you can. It's an ounce of prevention.
Is worth $1 million in cure.
That's right.
Okay, so hit like, subscribe, and comment. Until next time, stay safe, and thank you for watching.
Stay safe.